Welcome, everybody. This is Jeff Fowler with the Apartment Owners Association. And today we're talking about proper notice procedures for rent increases and evictions. And AOA, if you don't know, we've been around for over 40 years. And our goal is your real estate success. So we want to bring ideas to you that'll help you make and or keep more money than ever before. And this video is specifically for San Diego. San Diego County, the city of San Diego, Chula Vista, and the other, and for this area. So please hang on tight here. We have an in-person seminar that we've recorded, and we're just posting this because it was a sellout and there were other members that were not able to go. So here we go, we're gonna post it. Before we get into that, next month, there is another in-person seminar that I wanna mention. And that is conflict resolution skills for housing providers. And that should be quite interesting. And I want to encourage you to go to that. That'll be in March. So check the seminar schedule at aoausa.com. That's aoausa.com. And there's a seminars tab and you can register for that one. And that's free as well. And one thing I do want to mention, yes, we do have San Diego specific forms. And also we do have one form that we just posted, which is the 30-day pay rent or quit notice that's specific to the CARES Act. And that is one that our speaker today will be talking about. And so just want you to know that we do have that form. And all right, so yeah, our speaker, it's really from yesterday, but he has been in the landlord-tenant space for over 20 years as an attorney. And he's not just an eviction attorney, of course, he does landlord-tenant legal matters and other things as well. And he is the author of the quite popular column in the AOA magazine, which is the legal Q&A for San Diego. And so that's definitely one. If you read any article, read that one. Even if you don't read my article, at least read that one and just stay up to date on landlord-tenant law in San Diego. And he is the founder of Simone and Blevins Landlord Legal Center. And so it's my pleasure to introduce to you today our speaker, Franco Simone.
So we're going to be talking about terminating tenancies and the proper notice procedures. But before we get started, a quick review before we get started. Since COVID hit, there have been 17 new laws that were implemented that affect the landlord-tenant relationship. It's been wild, completely wild. We have new federal laws, we have new state laws, we have new county laws. Each city decided to maybe pass their own set of laws. And so it just became a complete mess. A lot of these laws conflict. A lot of these laws are vague because they were passed so quickly. And so we're trying to figure out all these new laws and how they're going to apply to each other. And so what we have here today is what I think the laws say, what they mean, and if there is a conflict, which way I think the conflict should be resolved. Now in the past, prior to COVID, it was fairly simple on what type of notices to give, how to give them, and it was, if you'd been doing it for a long time, there was no problems. Now it's becoming a lot more complicated, very complicated, on what type of notice you need to serve, how long is that notice. The notice that you need to serve is going to depend on what type of tenant you have. Is going to depend on what type of property the tenant is living in, where is the property located, what type of financing is on the property. And so it's not an easy question anymore. Well, I want to kick out somebody, I just serve them a 30-day notice and we're done. No, it becomes a lot more complicated. If we don't serve the right notice, then you're not going to be able to move forward and have the eviction. So it's important to know what to do. So moving forward, we're going to be talking about the limitations on terminating certain tenancies, how to serve the notices, and how to navigate the eviction process. Okay, we're dealing with, and what I'm going to be dealing with here today is basically the state law, okay, the Just Cause Rent Control Law, which is AB 1482. The city of San Diego passed their own law as well, and the city of Chula Vista also passed their own law. In the county of San Diego, those are the two cities that have passed their own law. So if you have units in El Cajon, you'll be following the state law. If you have units in San Diego, you'll be following the San Diego law and parts of the state law. If you have units in Chula Vista, you're going to be following the Chula Vista law and parts of the state law, okay? Other cities that are not here, that means they're just part of the state requirements. Does that make sense? So Del Mar, Vista, whoever it is, you're following under state law. But if you have units in San Diego and Chula Vista, you need to hear about what the exceptions are. So the California law first came into effect January 1st, 2020. It's called the Tenant Protection Act. This is horrible. Tenant Protection Act. It basically covers all tenancy that's more than 1 year old. In the city of San Diego, they passed their law June 24th, 2023. And basically, it exempts certain properties. All three laws exempt certain properties. It exempts houses and condos, as well as properties that are less than 15 years old. And you're exempt as long as you give an exemption notice. If you don't give your tenant an exemption notice, you're not exempt and you're subject to the laws. So it's important if you're in the city of San Diego or Chula Vista or wherever you're at, and you're renting out a home or a condo or a property that's less than 15 years old, you should be giving your tenants exemption notices so you do not have to follow the laws. Does that make sense? Okay, so those, and then Chula Vista passed theirs on March 1st, 2023. It follows similarly to the city of San Diego and the state of California that excludes houses and condos as long as you give them proper notice. Okay, so just in your mind so you can get this kind of clear, if you have an apartment, meaning anything above 2 units, you are subject to the just cause ordinance, assuming the property is older than 15 years old. If you have a house or condo, you are exempt, assuming you give them the exemption notice, okay? So for under the just cause rent control, you basically have 2 categories. One is no fault terminations, and the other one is at fault. What's the difference between the two? So if the law applies to you, if it applies to you, have an apartment, right? And it's older than 15 years old, and this law applies to you, you can kick out somebody when it's not their fault, which means, hey, I want to remodel the unit. Me as the owner want to move into the unit. And those type of exceptions you can do where the tenant hasn't done anything wrong. You can evict them, okay? The at fault is basically the tenant has done something wrong, and that's why you're kicking them out, and that's why you're giving them a notice. What could they do wrong? They failed to pay the rent. They have violated some obligation of the tenancy. Hey, you were supposed to get insurance, renter's insurance. You haven't. You're not supposed to have a pet, and you do. Illegal subletting. Hey, I only rented out to 2 people. You have extra people living there. Nuisance, illegal use, refuse to provide access. Whatever it is, the tenant failed in an obligation that they had under the law or your rental agreement, and that's considered at fault, okay? So those are the 2 categories, and then we're going to discuss what are the appropriate notices for each one of those. Okay, we're going to discuss the appropriate notices, how to serve the notices, and common mistakes that landlords do in the notices and acting with the tenants or corresponding with the tenants after the notice is served, and the landlord kind of does something that messes up the notice. So we're going to be covering those things. So the first one, no just cause rent control. So what does that mean? You're in a month-to-month agreement, okay? So, and these no just cause is basically, hey, I'm talking about houses, condos, right? Or buildings that are less than 15 years old. If you want to remove somebody in that situation, you have a house, let's say, anywhere in San Diego, Chula Vista, wherever you want to say it, and the tenancy is less than 1 year, you have to serve a 30-day notice. Okay? And if the tenant's been there for more than a year, you have to serve a 60-day notice. Fair enough. Kind of clean. Let's keep moving. Now let's assume that just cause applies. You have an apartment, right? The standard definition. You have an apartment, okay? How do I remove somebody? It's going to depend, okay? So City of San Diego, Chula Vista, basically, assuming you gave that it applies to you and they're not exempt, it's basically going to be either a 30 or 60-day notice, okay? It's a 30-day notice if it's less than 1 year, Okay? So you have to have a cause, a reason to kick them out, okay? And you got to give them a 30-day notice if it's less than a year and a 60-day notice if they've been there more than a year, okay? Under the state law, okay? Remember, the state law only applies to tenancies that are over a year, okay? So basically, you would have to always give a 60-day notice, okay? So far, I think we're doing okay. Now, it gets a little bit trickier, more specific tenants. If your tenant is a Section 8 tenant, okay? And basically, there's no exemption, so he or she's living in an apartment, okay? You have to give a 90-day notice. A 90-day notice for cause. Tenant, you did something wrong. This is what you did wrong. And here's your 90 days notice to leave for Section 8 tenants. Now, post-foreclosure notice, what does that mean? You bought a property, okay? And a tenant is living in there. They're entitled to a 90-day notice unless the person you're kicking out is a prior owner, okay? If it's a prior owner that you're kicking out, then you only have to give a 30-day notice. So post-foreclosure, meaning you bought the property in foreclosure, not in a straight sale. It doesn't matter in a straight sale. In a straight sale, the law applies like you're the owner. You've always been the owner. But in a foreclosure sale, you bought it at foreclosure. If it's a regular tenant, they're entitled to 90 days notice, okay? And a reason. And if it's the owner, they're only entitled to a 30-day notice. Okay. So those were examples for month to month. What if you have a fixed term lease? Hey, I have a 1-year lease. What do I need to do to terminate them? Okay. If just cause applies, if you have an apartment, you can't just terminate it if it's at the expiration of a lease. Does that make sense? I rented it to you for 1 year. Hey, tenant, you need to move out at the end of the year. It doesn't work that way. If it's an apartment, an expiration of a fixed term lease does not terminate the lease. Does that make sense? Which is different from what happened in the past. Okay, if the just rent control law does not apply, okay, so let's say it's a house. A house, the just law doesn't apply. Well, but you want to terminate a fixed term lease, a couple things. One is you have to look at your lease, okay? Figure out what the lease says. If the lease says the landlord is required to give a 30-day notice prior to the expiration of the lease, you're required to give that 30-day notice or a 60-day notice, whatever it says in your lease, okay? If you don't do that, you can't terminate that fixed term lease. Does that make sense? So you would have to get the notice. Other leases, other rental agreements, and there's thousands of different rental agreements, might not have any notice requirements. It basically might just say in a house, right, a house lease, hey, it expires, the lease expires, there's no notice required by either party, you're out at the end of the year, that's it. You don't have to give any notice and we can move forward. Okay?
Can I ask a question or later?
Let's save all questions for later or else we'll get bogged down. Okay, so that's a 30, 60, and 90 days the situation, right? 30 depending on how long the tenant's been there. If it's less than years, typically about 30, usually. If they've been there more than years, typically 60. And if it's a special situation, let's say for post-foreclosure or Section 8 tenants, and I'm assuming everybody knows what a Section 8 tenant is. Section 8 tenant is basically a tenant that receives money from the federal government to pay a portion of their rent. So if you have you'll know if you have a Section 8 tenant because you'll get a check from HUD basically paying part of that rent. They're entitled to 90-day notice. Now, if we're going down the path of the second category, at fault, meaning the tenant did something wrong, what notices do I need to give? Again, if the tenant failed to pay the rent, is breaching the lease, committing waste, subletting, illegal subletting, using the premises for an unlawful purpose, causing a nuisance, blah, 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 what do I need to do? Okay? So basically, if just cause applies, if you have an apartment, right? We're not talking about houses. If you have an apartment, right, you have to serve a 3-day notice to perform. Okay, so let's say the tenant has, I'm going to use pet, I know that's going to get me in trouble, but let's say they're illegally subletting. Okay, hey tenant, I rented it out to 2 people. There's 2 other people that are living there now. You serve a 3-day notice to perform, get rid of these people. After that expires, and you go there and you notice that the people are still living there, then you have to serve a 3-day notice to quit. Hey tenant, I served you a 3-day notice to perform. You failed to perform. Now in 3 days, your contract is going to be terminated. What if you don't give the extra 3-day notice to quit? If you file an eviction, you're going to lose. So you have to do a 3-day notice to perform, 3-day notice to quit, and after both of those time periods are over, then you can start basically kicking the tenant out. Now, there's one exception to this, and part of the reason is, well, why do you have the two notices? Because the tenant can cure the breach. So the legislature wanted to give an opportunity to the tenant to say, look, tenant, you did something wrong. Maybe you didn't realize you did something wrong. We don't want the landlord to terminate your rental agreement. We're going to give you an opportunity to fix it, right? And so that's why you're giving a 3-day notice to perform. If the tenant got rid of the excess people, then they have a right to stay, right? Because you gave them notice, get rid of the people, get rid of the pets, get rid of, clean up, don't store things outside in the common area, whatever it is. They performed, they did it, they're allowed to stay there, okay? But after 3 days, if you notice the breach is still there and you need to get evidence of that, right? As an attorney, I would be like, okay, have you gone there after 3 days? Have you seen the people still there? Have you noticed that the dog is still there? Have they cleaned up the mess in the common area, right? Send me a picture, or do you have testimony, or whatever it is. Yes, I saw this, I have pictures, blah, blah, blah. Okay, great, we'll do a notice to quit now, because they can no longer cure it, they had an opportunity, and now we're gonna go after them to try to quit. This excludes the non-payment of rent, right? Because technically, they could cure a non-payment of rent. So in non-payment of rent, they just have a 3-day notice to pay rent or quit, that's it. If they don't pay within the 3 days, it's over. You don't have to do a 3-day notice to quit. Does that make sense? So all the other curable breaches, they have to be given a period to cure and then a 3-day notice to quit. Except for rent, they just get a straight 3-day notice to pay rent or quit. If they don't pay within those 3 days, then you're able to kick them out. Okay? Okay, some additional requirements, these little quirks. The CARES Act. The CARES Act is basically a federal law that was passed in 2020 in reference to COVID. This is where I spoke earlier about if you have a mortgage on your property, let's say you have an apartment building, if that mortgage is backed by the federal government, and you could say, I don't know if the mortgage is backed by the federal government, I initially got it through Wells Fargo, they sold it 15 times, and it's okay, you can give us the address. There's a website that the federal government set up where we can put in your address and we can see whether or not your mortgage is federally backed. If it is federally backed, then the CARES Act applies, okay? And basically means you can't give a 3-day notice to pay rent or quit, you have to give a 30-day notice to pay rent or quit. So that's always fun. And then the other thing also, other programs besides the federally backed mortgage is Section 8. So Section 8 is considered a federal program, because it is. And so they would also be required to give a 30-day notice to pay rent or quit. And that also applies to any other type of monetary obligation under the lease. Hey, you need a tenant, you're supposed to pay a water bill. That's a monetary obligation. They would be entitled to a 30-day notice, right? So anything like that, water bill, late fee, maybe security deposit, anything that deals with money, they're entitled, and it's federally backed mortgage or Section 8, they're entitled to a 30-day notice to perform those monetary obligations. But other stuff, let's say illegal subletting, no, you just do the 3-day plus the 3-day to quit. Let's move on. Some other restrictions for Section 8, okay? When you serve the notice, you also need to serve the notice on your Section 8 caseworker. A lot of people don't do this. So if you come to me and you serve the notice, did you serve it on the caseworker? No, I didn't. That's not sufficient. Serve the caseworker, and then the time period is going to start again. Does that make sense? So if you served a 30-day notice to pay rent or quit on January 2nd, but you didn't serve the caseworker, then you finally came to me on the 15th, I'm like, we need to serve the caseworker. It's going to be, the service will be completed 30 days from January 15th when we completed service on the tenant and the caseworker. So you got to make sure the caseworker gets a copy of the notice. Also, part of the notice has to be documentations dealing with Violence Against Women Act, okay? It just basically tells people that might be in that type of situation what their rights are. So part of the notice is actually like a, 10 page, 11 page disclosure that's given to people who, and basically informs them, hey, if you're part of this class of people that are having issues at home, here's your various rights. So that has to be attached to the notice as well. So now the notice is 13, 14 pages long. So that's always fun. Okay, so those are, as you can tell, it's a lot more complicated than before. Before it's like, 3-day notice, you didn't do something, get the heck out. Or a 30-day notice, you want your place back, get the heck out. Or your lease is expired, I don't want to renew, get out. But now, who's your tenant? Like, here's an example of who your tenant means. In the Chula Vista ordinance, you know, if you do a 60-day notice, and let's say you want to remove a tenant because you want to remodel the unit, you know, if your tenant's disabled, the relocation benefit is going to be 3 months as opposed to 2 months if your tenant's not disabled. If your tenant's elderly, okay, then they're entitled to 3 months, as opposed to if they're not elderly, they're entitled to 2 months. So that depends on, well, what do I do? You know, what notice do I need to serve? Well, in that notice, I need to know who the tenant is. How old are they? Are they disabled? Blah, 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 to figure out what I put in the notice to serve them. So that's just an example. That's just in Chula Vista. We don't have that in San Diego. In San Diego, the relocation benefits, it doesn't matter who the tenant is. They're basically entitled to 2 months relocation benefits if you serve them a notice, let's say, because you want to remodel the units. Okay, so now I'm going to move on. How do I serve the notice? Okay, the biggest mistakes people make here is you have to do this in order, okay? You first have to try to personally hand the document, the notice, to the tenant. Now, you can serve the notice. You can have a maintenance person, the property manager, have your law attorney's process server do it, but they need to first try to personally hand it to them. That means they actually have to knock on the door, ring the doorbell to make sure nobody comes to the door. Well, what if I just go out there and I just post it on the door and mail it to them? I don't knock. It's not proper service, you're going to lose. Okay? So if we go to trial and then somebody's there is like, I posted and mailed it, either I or the judge is going to ask, when you went there, did you knock on the door? Yes, I did. I knocked 10 times. Great. And nobody came to the door. Okay, great. That's when I posted a mail. But if you testify, no, I just went up there, I was in a rush, I just posted and dropped it in the mail, improper service, and you're going to lose. Okay, so the first one is you actually hand it to them. Here, tenant, here's your notice. Sometimes they don't want to take it. There's some cases out there that basically say, if the tenant knows what it is, hey, tenant, I have a 3-day notice to pay rent or quit. They don't want to touch it. You inform them what it is that you're trying to serve them with them, and you can technically leave it at their feet. Now, I don't recommend you do that because it was a rare instance, but try to hand it to them the best you can. If you know where they work, you need to try to serve them personally at their work. This is another thing that people kind of mess up. Well, I went to the house, nobody was there. And then I posted a mail. And then we end up in a trial, and the defense attorney asks, well, do you know where they work? Well, yes, I have their information on the application. And they still work there. Yes, they do. Did you try to serve them at work? No, I didn't. Improper service, we lose, right? So one of the questions when you guys call up and say, hey, I went there and posted a mail, did you knock? Yes, I did. Do you know where they work? Well, no, I don't. Or yes, I do in the application, but she left that job and I don't know where she's working now. Great. Or hey, she works for herself. She works from home. Well, there's no other address to serve them. Okay, so you first try to knock and try to hand it to them. If that doesn't work, you go to step 2. Step 2 is some other adult comes to the door. You knock on the door. Your tenant is Jim. Is Jim here? No. Who are you? I'm Suzanne. Just a friend. Okay, Suzanne, this is for Jim. You hand her a copy and try to mentally know who she was. 26-year-old woman, 5'5", blonde hair, somehow describe her, and then you mail a copy to Jim. Does that make sense? What if a 10-year-old comes to the door? I don't think you should serve a 10-year-old. I don't think it's going to be enough. I mean, at a minimum, maybe a 16-year-old, but I would say at least an 18-year-old, an adult. So if the child comes to the door, and it happens a lot, that's not going to work. So you tried one, you knocked on the door, a kid came to the door, is your parents here? No, they're not. I can't leave it with that person. I'm going to post it and mail it. Fair enough? Okay. Now you do 1, nobody comes to the door in 2, then at that point you can post it. You post it on the door. You seem, well, that's simple. Well, what if the tenant doesn't usually go through the front door, right? A lot of times, let's say you go into the garage, right? Or they go through a side gate. If you know there's a different way that the tenant comes in, I would recommend you post it on both sides. You post it on the front door and you post it on the gate or the side door that you know the tenant always goes through because they never go through the front door. Just throwing that out there, okay? And then you mail it. Certified mail, registered mail. Don't send it certified. Don't send it, you can send it registered because registered mail is basically proof that you mailed something. The statute specifically says just U.S. first class mail. What does that mean? Just when you just mail something regularly, that's considered U.S. first-class mail. With certified mail, the reason why it doesn't work is the statute doesn't say certified. It just says U.S. first-class mail. With certified mail, they have to sign for it. If they don't sign for it, they never got it, right? So you got nowhere. So just drop it in the regular mail to their address at the place. That's your place, okay? Okay, how do we calculate the 3-day notice? So let's say you're doing a 3-day notice. Now I'm focusing on 3 days because it's usually more of a mess than a 30 or 60-day notice. So you cannot count weekends and you cannot count judicial holidays. So for example, let's say an easy one, well, Monday, you don't count Monday, so it's Tuesday, Wednesday, Thursday is the last day. But let's pick a day that's over the weekend. So let's say you serve them Thursday. You don't count Thursday because that's the first day. You count Friday. Saturday doesn't count. Sunday doesn't count, right? Monday counts and Tuesday counts, so the last day is Tuesday. Why is this important? Let's say you serve a 3-day notice to pay rent or quit. You don't, and let's say you served it on Thursday, and you're thinking, well, Thursday, Friday, Saturday was her last day to pay. I don't need to accept money on Monday. If she came up with the rent to you and say, here's my rent on Monday, she's within the 3-day period, and you should have taken the money. By saying I don't want it, right, you basically kind of terminated your notice. If it goes in front of the judge, I try to pay the landlord, here's my cashier's check, it's dated for Monday. She told me it's too late, and Your Honor, it's not too late because I had technically until Tuesday, right? So that's why I'm going over this, so you know how to count it. So don't count weekends and don't count judicial holidays. Labor Day, New Year's, all those type of days. If you're unsure a particular holiday should be counted, just assume it is and go from there, or call my office and say, hey, is this holiday a judicial holiday? Because some aren't and some aren't, and we can go from there, okay? Let's keep going. Keep going. Do's and don'ts, other stuff. During the 3-day or 30-day period, right, if it's a Section 8 person, right, or CARES Act, you have to accept full rent. Let's say the rent's $1,000, right? They come up with $1,000. You can't say, I don't want it. I want you out. It's not going to work. If the evidence comes out showing that you should have, they try to pay it within the time period, right, then you're required to take it, and the law will assume you should have taken it, and if we file an eviction, you're going to lose, okay? What about if they mail the rent, okay? It's got to be postmarked. It's not when you receive it. It's got to be postmarked within the 3-day, 30-day period, right? So let's say it was served on Monday. They have until Thursday. It's postmarked Wednesday, but you got it the following Monday in the mail. You look at the postmark. If it's postmarked within that 3-day period, excluding weekends and judicial holiday, they've paid it during that period. Does that make sense? Okay, so you have to accept it. Don't not accept it. Well, what if it's partial payment? If it's a partial payment, they owe you $1,000, they come up with $900. It's up to you if you want to take it or not. If you take it because it's $900, you have to know that your notice is no good anymore. You have to turn around and serve a new notice for a new 3-day notice to pay rent or quit for $100. Now, sometimes I recommend my clients to take the money, right? So let's say the tenant's behind $10,000 in rent. The rent's $3,500 a month. They're behind 2.5 months, and they come up with $9,000. Obviously, in that situation, take the $9,000, deposit the check. Let's turn around and serve a new notice for the $1,000. But let's say the rent's, $1,000, and they come up with $100. You don't have to accept it. You're like, look, I don't want to go through the expense of serving a new notice. It's going to cost me more than $100 to get it drafted and served. I don't want the $100. You need to get out. Does that make sense? So you can make the decision. But if you do take the money, you have to turn around and serve a new 3-day notice. If you don't take the money because it's a partial payment, you have every right not to take partial payment. What happens a lot is tenants will deposit the money in a bank account or through different portals that landlords might have. Portals meaning whatever the different thing is, and they automatically do it. You need to check your bank account. I can't tell you how many times I'm getting close to trial, and the notice expired 3 months ago, and then all of a sudden my client calls me up, oh, I just checked my bank account. She's been depositing money for the last 3 months. And I'm like, okay. So at that point, we have to decide. We can turn around and say, we just found out about it, and we're returning it, and try to convince the judge we just found out about it 3 months later, and we didn't accept it and we returned it. The longer you hang on to money from the tenant, the more likelihood the judge is going to be like, you accepted the funds, it killed your notice, you're not going to be able to evict them based on that notice. Does that make sense? So on these portals, after the 3-day notice expires, some of them you can stop them from depositing funds, right? So do that. Other ones you just can't. They have your bank account information. You really don't want to close your bank account because it's a hassle. You have a bunch of other tenants. Just keep an eye on your bank account, right? As soon as you find out, oh, 3 days ago they deposit extra money, great. Thank you for telling us. We're going to work up a quick letter. Here's a check. We're returning your $1,000. We don't accept it. It's beyond the 3-day notice. So as soon as we found out, and then that's perfect evidence. Hey, Your Honor, she deposited. I told her I wasn't going to accept money anymore. She deposited $1,000. I found out about it 3 days later. Contacted my attorney. We sent the letter saying, here's your money back. Judge would be okay. They didn't accept it. Okay. You cannot accept. Save questions for the end. You cannot accept rent beyond the notice period. Does that make sense? So let's say you ask for February's rent. Tenant, you owe me $1,000 all the way up until February 29th. They come around and they pay March's rent. You just invalidated your notice. By accepting rent beyond the notice period, the law views that as a waiver of your 3-day notice to pay rent or quit. Well, how does that normally happen? How it normally happens is, let's say you're prorating the rent. You serve a 30-day or 60-day notice, right? And the 60-day notice expired February 7th, right? And you thought there was 28 days in February instead of 29, so you accept an extra $3 than you should have. If you accept 1 penny more than you should have, it waives your notice and we're dead in the water. Does that make sense? So be careful with proration of rent. Make sure you calculate it, exactly what you need to do, and you can avoid those situations. There's other. So let's say that you serve a 30, 60, or 90-day notice, and then tenant moves out. They still owe you $6,000 worth of rent. What can I do? Obviously, you're not going to file an eviction because it wouldn't be proper because you have possession back, right? You would file a small claims action. Small claims court, they just recently increased the limit. It used to be $10,000. Now they increased it to $12,500. So let's say he owes you $15,000. I would still recommend go to small claims court and ask for the maximum, the $12,500. You're waiving the extra $2,500. Why would I recommend that? Because if you have to hire an attorney, that lawsuit's going to last a year and a half. And you're going to pay me more than $10K over a year and a half to try to collect that amount. So go to small claims court, get that filed, and try to get your money back if the tenant happens to move during the notice period, whether it be a 3-day, 30, 60, 90. All right. Like we talked about, you can accept rent up until the expiration of the notice, right? So let's say your 30-day notice expired at the end of February. Great, you can accept February's rent. You don't have to be like, well, I don't want to accept any rent at all. You're entitled to accept rent up until the end of the notice period, okay? And we talked about number 2 there. Now, if you serve a tenant a notice and it's a no-fault notice, hey, I'm remodeling the premises, or hey, I'm the owner, my child is moving into your unit, you're required to notify the tenant that they're allowed to have a pre-move out inspection. A lot of leases these days, and I believe the AOA lease has this, it has a notice in the lease already. So in the lease, they'll say, hey, tenant, if you're going to move out, by the way, you have the right to a pre-move out inspection, right? If it's not in your lease, you need to tell the tenant you have a right to a pre-move out inspection. What does that mean? Before the tenant moves out, let's say at the end of the notice period, anytime 15 days prior to them moving out, they're allowed to have you come over to the unit and point out to them and put it in writing all the things they need to do to get their security deposit back. Okay? If you don't do that, then they have reason to basically ask for all the security deposit money back because you didn't give them an opportunity to have that inspection. So let's say you do an inspection. You got to make sure you clean the oven, you got to make sure you clean the refrigerator, hey, fix this broken window, blah, blah, blah. After they move out, you do another inspection, right? The final inspection after move out. Hey, you didn't fix the window, I'm charging you for the window. Or hey, you did fix the window, you did clean up, here's your full deposit back. So if they made the repairs, obviously don't charge them. If they didn't make the repairs, then you can charge them. If it's something that you couldn't see during the pre-move out inspection, let's say there was a hole behind the couch and the couch was up against a wall. You didn't see it. But now that the belongings are gone, the sofa's gone, and you see a big hole, you can charge them for the hole even though it wasn't written down on your pre-move out inspection. Okay? So don't forget that, because a lot of people forget that. And then all of a sudden you get sued in small claims court. They want the security deposit back, and they argue, we were never given notice of a pre-move out inspection. And then at that point, it's going to be like, ooh, you might lose just because you didn't give a notice, even though the charges are legitimate. Okay? Okay, so what if it's a perform covenant or quit? Here's a 3-day notice. Tenant, you're doing something wrong. Here's a notice telling you you're doing something wrong. You need to cure this. You need to resolve this. Okay? So you can accept payment, okay, and you should accept for a monetary breach, right? Hey, you failed to pay the second half of your security deposit. You have to accept it if they come up and pay it. Allow the tenant to cure, okay? Sometimes the landlords don't want to deal with the tenants anymore. So you're telling the tenant, hey, clean up this mess outside. Tenant calls up, hey, I need the gate open in order to get my stuff out of the complex. Can you help me out? And landlord goes, nah, you're on your own. You don't want to end up in court and say, Your Honor, I tried to cure this. I asked the landlord to open up this gate so I can get stuff out. He refused to open it. So whatever you need to do to help the tenant cure the breach, the law expects you to, do what you need to do to allow them to cure it within the time period. We already talked about not accepting payments after the 30-day period. And don't make yourself unavailable to communicate. A lot of times they serve a notice, tenant's calling, trying to get some type of information so they can try to cure the breach, and the landlord never calls back. Again, that's not going to look good. Don't do it. You're going to end up at trial. Look, I emailed my landlord 3 times. I called him 4 times. I was trying to do X, Y, and Z. He never got back to me. The judge is going to be like, why didn't you go back to him? Right? He's trying to cure. You give him a notice, and you're not corresponding with the person. That's not going to be good as well. Okay. Okay, common issues with notice. In a 30-day, 60-day, or 90-day notice, you have to have abandonment disclosure, abandonment language in the notice. What is that? It basically deals with abandoned property. If you don't have that statutory language in your notice, and recently I had a case, a client came up with a 60-day notice. They kind of piece it together, and I'm like, okay, everything's fine, but you're missing this language dealing with anything that's abandoned there might be subject to X, Y, and Z, blah, blah, blah. It wasn't there. Because it wasn't there, the notice was no good. Okay? Any notice, 3-day, 30-day, 60-day, somebody's got to sign it. Don't deliver an unsigned notice. Does that make sense? Somebody's got to sign it. And it's better if it's somebody that the tenant recognizes, right? Your signature, the property manager's signature, somebody that they know, the repair person, whoever it is. Because if they get a notice and they don't recognize it, signed by Jim Long. Well, Your Honor, I don't know who the heck Jim Long is. My landlord is, Jenny, and I don't know anybody. I thought it was a fake, right? I don't know who this person is, right? So could we get by it if it was somebody else the tenant doesn't know? Probably. But hey, you sign it or have a property manager sign it. If it's blank, it's not going to work. It's going to be invalid. Your Honor, it wasn't signed. I didn't know if it was even valid, so I just threw it in the trash, right? Make sure you have the full legal correct address listed on the notice. You would think this is easy. I've seen so many notices with the wrong zip code, right? Client, I looked up the address. It should be 92108. You have 92107 or whatever it is. Well, if it's wrong, it's wrong. The notice is no good. The other one is, let's say Long Branch Street. It should be Long Branch Avenue. Doesn't work. So make sure you have the correct full address on the notice. Rent periods must be correct. Hey, January's rent. January 1st, you owe me $1,000 from January 1st to January 30th, 2024. What's the problem with that? January has 31 days, right? February screws up people all the time. February 1st to 28th. Well, this year it happens to be 29. It's wrong. At the end of the year, what do I see all the time? You owe me January's rent for January 1st to January 31st, 2023. No, 24. Let's do it again. So beware of those simple things that really can mess you up. And obviously on 3-day notices, do not include anything except for rent. No late fees, no unpaid utilities, no security deposit that hasn't been paid. Sometimes you might be able to get around that if you have something in your rental contract that says any monetary obligation that is due under this lease shall be considered quote unquote rent. If you don't have that language in there, if it's 1 penny of late fees, you're dead in the water. Okay. Okay, so now you have the notice expired, they haven't done what they're supposed to do. What the heck can I do now? Can I just go kick them out? Obviously, no. You're not going to do that. The penalties for self-help, where you just go out there and lock people out, could be up to $2,000 a day, plus attorney's fees and costs. I don't care what the heck they're doing out there. If the cops are out there 20 times, do not lock them out, okay? And I get these calls, hey, I locked them out. Go out there, unlock it. I changed the lock. Go out there, give them a key immediately, so at least we can say, hey, I just changed it, and I was just waiting for the tenant to give him the key back, right? You got to be careful, because otherwise you get a nasty lawsuit on the other side, and then you're hiring me to fight $2,000 a day that you kicked out somebody maybe forever, right? Because they got kicked out, they weren't able to get back in, and then 3 months later they finally found another place. You have 90 days times 2,000, plus there could be punitive damages, even more above that, plus attorney's fees and costs. So don't do that. Okay, so what do you got to do? You got to file the unlawful detainer. Unlawful detainer is basically an eviction, right? It's supposed to be a summary procedure, right? It's supposed to be quick. Lies, it's all lies. So there's generally 2 types of cases, uncontested and contested. Uncontested means the defendant did not file an answer. They did not respond to your lawsuit, okay? Contested means they filed an answer. They responded to your lawsuit. It doesn't have to be an answer. It could be something else. But they filed something in response to your lawsuit. And so, it's going to take different paths, and we're going to go through it. In the past, I've known people, property managers, hey, I've been a property manager for 20 years. I can handle filing the unlawful detainers. They know what they're doing. Great, that's fine. Post-COVID, there's no way in heck that if you're not an attorney doing this full time, you're going to know what the heck to do with the unlawful detainer. So don't try. You're going to try, you're going to spin your wheel for about 3 months, and eventually you're going to call me and say, I filed this back in July. I can't get my paperwork passed through. I'm having problems with the clerk. Can you take a look at my paperwork? I look at the paperwork, it's like, your paper is wrong, your notice is wrong, you filed too early, or this, X, Y, and Z. You need to start all over. Or, hey, you might be right. We can take a shot. Maybe we'll settle it before we go to trial. If we go to trial, I'll give you 50-50 chance we're going to win because it wasn't done right. It's just very complicated. Even when we file cases now, we get it drafted. We have multiple people look at it to make sure we have crossed all our T's and dotted all our I's, because there's so many variables out there. There's so many laws. We got to make sure that we cover and that we've actually looked at when we file the complaint, because we don't want to file a complaint that later on we're going to lose on. Does that make sense? Okay, let's keep going. An uncontested, which means they do not file a response. We file the summons complaint. We get it back from the court in a couple days. We served it. You cannot serve it as the plaintiff. You cannot serve the summons and complaint. You can serve notices. We get them served with summons and complaint. They have a certain period of time. If we serve them personally, they have 5 days. If it's subserved, meaning we serve some other individual, they're going to have 10 days. If it's any unknown people, they're going to have 15 days. So it all depends. So once all these time periods expires, we can file a default judgment. We can get what's called a writ. A writ of possession is instructions from the court to the sheriff to do the lockout. From the date that we filed the default judgment, it's taking currently about 2, 3, 4 weeks to get the writ. Once we get the writ, it's taking the sheriff's department 30 to 45 days to doing lockout. About 6 months ago, now pre-COVID, I could usually do an eviction about 45 days. After COVID, and if you would have called me 9 months ago, it was taking 1 year to complete an eviction. Right now, we're giving estimates of about 5 to 6 months to complete. So things have gotten a little bit better. Well, a lot better, right? We're not doing 1 year anymore. We're up to around 5, 6 months, right? Assuming, this is Chase, my paralegal, assuming they don't do crazy stuff. They don't file bankruptcy. They don't remove the action to federal court. If they do that, you're going to burn another 2 or 3 months. Okay? Let's keep going. Okay, contested, they file a response. Okay? So that means we have to go to trial. The trial, they're supposed to set it within 21 days of when we request it. Once the trial's over, the same thing. It's going to take 3, 4, 5 weeks to get the writ, 30 to 45 days to get the sheriff. And with this situation, you're going to be pushing more of the 6-month period as opposed to maybe the 4 or 5 month period if it's a default. Okay. Okay, now navigating this stuff. The court's still backlogged. The good news is we do have a new judge The judge came in about 6 months ago. About 6 months ago. She's doing things a lot quicker. She seems to be a little bit more organized. She came in when UD's evictions were taking a year. There was a lot of problems with that. So she's the one that's basically been pushing things along to try to get a tighter timeline of about 6 months. So that's good. The clerk's office is learning their forms a little bit better. Because of all these new laws, imagine every time there's a new law, the court has to set up new forms. So the law passes, we try to do stuff, we would submit things, and then because we're on the old forms, the clerk's office, because they're backed up, look at it finally 3 months later, then we get it kicked back. Oh, by the way, 2 months ago, we had a new form. Now you need to use this new form. They don't notify us, of course, until we get the kickback. Here's the new form, and we're not going to tell you how to fill it out. So if it's confusing, good luck. Just try to do the best you can. So that's why things were taking a year. Laws would pass. The clerk's office didn't have the forms yet. They were hanging on to things. Then we finally get the forms back 3 months after our initial file. We resubmit. We wait another 2 or 3 months to get it back and hope we did it correctly. And like I said, all these new laws require additional forms to be filed. It makes the process a little bit more burdensome. Okay. So what are we doing these days? We're doing a lot more settlements. The sooner we can do a settlement, which basically means stipulate to a judgment, stipulate to a move out, stipulate to maybe a pay and stay. Hey, tenant, you can stay here, but you got to make these payment amounts. 30 days, you pay X. Every month, you're going to pay the rent plus an additional $200, $300 to try to catch up. As long as you make these payments, you can stay. That's a pay and stay. Or typically, most of them are just move out. Look, we'll give you an extra 30 days, 45 days, 60 days to move out, right? And you owe us X, or we waive the rent, or whatever it is, if you timely move out. Okay, so the sooner we can reach some type of settlement, the quicker I can get the paperwork started so we can get the writ and get the sheriff out there. Does that make sense? So if we can settle things month 2, right, then hey, the sheriff will be out there in 2 or 3 months. But if we wait after trial and we're already at month 3.5, and then we go to trial or we submit the agreement at trial, then we're still waiting another 2 or 3 months for the sheriff and the writ to be issued. So we're doing a lot more settlements. It also keeps our costs down. Right now, currently, so I don't know, for the old timers, including me, back in the day, we had 4 courthouses that handled evictions: Vista, El Cajon, Chula Vista, and downtown. About 7, 8 years ago, they reduced it to Vista and San Diego. About 3 or 4 years ago, they reduced it to San Diego. All San Diego County, all 4.2 million of us, all the apartments there, all the evictions happen in one department, Department 501 in downtown. Every morning they have 25 trials, and every afternoon they have 25 trials. So you have a judge trying to handle 25 trials. So how does it work? If anybody says that their trial is going to take longer than a half an hour, she ships us out to a different department. When we go there, the judge is either going to be ready to hear us, or is going to be, you know what, I'm stuck with something else. Can you guys come back next week or in 2 weeks or whatever it is? If the judge can handle it, then hopefully you get started in the next 1 or 2 days. But out of those 25 cases, I would say a good 10, 12, 15 settle, right? They already have a settlement agreement when they show up, or something gets settled on the day of trial. If they can't handle your matter in the morning, guess what? You've been there since 8:30, 12 o'clock comes around, they still haven't gotten to your matter, you come back at 1:30, right? And then hopefully they hear you sometime between 1:30 and 5 o'clock. So you might sit there for a whole day waiting for them to hear your case. So that's the nightmare that's going on right now in the courthouse. And so it is what it is. So if you settle it, what does that mean? You and I are not sitting there for 4 hours waiting for a matter to be heard, right? And so that's a cost to you. If we can settle it the first hour or settle it before trial, you're not paying for me to sit around for 4 hours waiting for a case to be heard. Okay, virtual trials. They're still doing virtual trials. What does that mean? You don't physically need to be in the courtroom, okay? So I typically have my clients come to my office. We sit in our conference room. We're on the computer. The court can see us. We can see the court. We can see the defendants if they're there. 2 days prior to trial, we're required to submit all of our exhibits to the court and to the other side, as well as our witness list, okay? So when we go to trial, the court already has up on her computer all of our exhibits that are labeled. And then we're basically there. If I'm taking your testimony or testimony of property manager or whoever else, you're in my office. Hey, exhibit number 1, is this the lease agreement? The judge has it in front of them. The defendant got our documents. she has it in front of her as well, and we kind of do the trial that way, and we kind of go back and forth. So that's nice, right? Because if we can spread out in the office, you don't have to, it's horrible going downtown. Parking's expensive. You have to get half naked to get through the security, to get into the building. So it's nice you just come to my office, you park, you stay there. If you need some coffee, you need to walk around, you need to grab lunch, you can do it, and you're not worried about hanging out in the hallway for 4 hours. Sometimes it makes settlements more difficult because we're not physically there. And a lot of times I'm calling the tenant while we're in trial, meaning waiting for a case to be heard. We do still do stipulations. We email it to the tenant. Tenant can electronically sign it. We can sign it as well, and then we electronically file it with the court. And then if we do that, I can chat the clerk on the virtual, basically saying, hey, we settled the case, take it off calendar, and we'll file the agreement with the court shortly. But sometimes, even yesterday, very difficult tenant. I'm like, there's no way in heck I'm going to be able to settle this over the phone. I think technically she was probably on something or was having issues. I drove down with my client down to the courthouse because I thought, okay, the only way this is going to happen is where I'm face to face with her. I can talk with her and we can work out some agreement, and we're able to do it because I just could tell on the phone she just wasn't able, and I couldn't see how she was going to be able to open up an email and actually sign something electronically. So it all depends. We'll do what we need to do. Let's keep going. Okay, so wait, let's talk about rent control. A couple things that recently happened. So we're in a state of emergency. There's a law out there that most people aren't aware of. Whenever there's a state of emergency, no matter what apartment you have, right? This includes houses and condos, because technically houses and condos are sometimes are exempt from rent increases. But during a state of emergency, you cannot increase the rent more than 10%. So even if you're exempt under other laws, right now we're in a state of emergency. Earlier we were in a state of emergency with COVID, the fires, and now because of the flooding. So you can't increase the rent more than 10 days. Just recently again, also, the County of San Diego passed a law, I think it was like 2 days ago, I haven't even seen it yet, 3 days ago, basically saying you cannot increase the rent during the time period where they passed this law. I don't know how long it is yet. So any old rent increases before the law was passed are still good.
I think that's limited to certain zip codes.
To certain, yes, so a certain zip code, and I'm not sure how long it's for either.
60 days.
Okay, so 60 days, certain zip code, we have to figure out whether or not you're in it. You're not allowed to do a rent increase. Old rent increases are okay, but that's something else going out there. Now, the rent increases, you guys know, it depends on where your units are located. Obviously, in the San Diego region, there's a certain figure data that's produced by the federal government. We use that plus 5% to determine what you can increase the rents currently, okay? So that's the number you have to figure out what it is, and then that's the max that you can increase every year, okay? So you need to figure out when your last increase was. It has to be more than a year ago. You can do more than one increase as long as the total of the two isn't more than what you're able to do. Does that make sense? So what you should probably do is if you're interested in increasing the rent, hey, I have a 12-unit building, I want to increase the rent, call somebody, call an attorney, call my office, some other attorney, it doesn't matter. Hey, what can I increase currently? What is the amount? Oh, it's 9.2, or it's 10%, or it's whatever it is. Currently now, because we're in a state of emergency, even if you're exempt from the rent control laws, you have a cap of 10%. Okay? So